My country people, news they reach us say they don't drag Bola Ahmed Tinubu leg come out again onto the matter of the forgery certificates. Atiku on his own, he no one rest for this matter. Or when you hear him, he say he wants to see the end of this matter. Because even the Chicago State University, they won't see him say whether not they lie or not Tinubu they lie. The OT don't become something of the law right now. And Chicago State University say they don't ready, say they will talk truth. Okay. Meanwhile, as this one they go on, Tinubu Day New York, they go they read excellent speech about Nigeria. Bueno, muy bueno. Very good speech. In fact, he say Africa is nothing less than the key to the world future. Okay, now. As this one comes to Bolofo, come the year waiting the apple for Kanu. Say the governor way did there where they put for there from the New People's Party. Say they don't swear well at them. They don't put APC on. Say the judiciary verdict wey they give, say e no favour the governor wey dey. Say na the one wey dey APC na in favour. In fact, as we dey talk so, APC dey rejoice say na they win. Na wow. E favour some, e no favour some. Okay As this one come still bolofo news come dey reach us say the election wey wan happen for Imo State, e don cause katakata say unknown gunmen come kill 8 joint task force officers for Imo State. My people, it was horrible. In fact, if you see and they burn them, some people too wicked. Now you they roast human being like so now they roast animal. My people, this life, if you no catch una men on uniform, una just die them like that. May their soul rest in peace. Corruption I cause all this katakata, so our president they go they make mouth for the overseas where they travel, they go say one fight corruption. When we know where the corruption for start. Talking about corruption, we got a year say Nigeria Anti-Corruption Body EFCC declares 2 wanted over 300 million fraud. Another wanted for internet scam. Now new thing. These people know who thief better money. It's just million. What about our politicians who thief in billions and in trillions? How many times you don't say they don't arrest them? How many times you don't say they don't throw them for jail? They'll talk say they've been given 20 years imprisonment because of what they do. Okay, you guys are not showing example. But now they use the ones so you say they don't get head. They take their skills, their talents into the same thing we wanna teach them, because now they fight for now. When you reach election time, now go they use them. When you guys enter, now not go give them job. What do you guys expect? Of course, they go enter the internet where they sabi do. My people, this life, I dey talk not balance.
As you are aware of the ongoing proceeding at the District Court in Chicago, United States, where Atiku is pleading with the court to order Chicago State University to release Tinubu's academic records, Honorable Judge Gilbert just granted the order. Everything that Atiku is seeking must be delivered to him within 2 days. Let's quickly see what Atiku is seeking and then proceed to what the judge ordered. Atiku is seeking many documents. Let's start with number 1. Chicago State University will produce certified true copies of the certificate template that the school issued in 1979. This means the sample of the certificate they issued that year. Of course, it must be uniform. No university will print different certificates for different departments or students. Number 2, they will produce a copy of the certificate they issued Tinubu in 1979. Number 3, they will produce a certificate that looks like the one Tinubu submitted to INEC, but with another person's name. That's if they have this type of certificate. Remember that Tinubu's counsel argued that CSU made errors on the certificate they issued him. On the other hand, CSU's counsel disowned Tinubu's certificate in court that they do not know where he got it from. Number 4, Atiku is also seeking CSU documents that were certified and produced by one James Orr, their general counsel at CSU, as well as communications relating to these documents. This one has many parts. We will take it one by one. Atiku wants an oral deposition from a staff member that CSU will appoint, preferably someone working in their registry department. He wants the person to answer some questions. Number one, the authenticity of the documents produced by CSU in response to the application and how and where CSU got the documents. Number two, Atiku wants to know CSU's position on the authenticity of other documents related to Tinubu purportedly produced by CSU in another Nigerian proceeding. This one is talking about the Nigerian lawyer Enahoreba, who got all the documents from CSU last year. More on this in a moment. Number three, they will produce contents of Westberg affidavit. This is the person that deposed an affidavit that Tinubu graduated from CSU. Mind you, he didn't lie in this affidavit because they have a record of one Bola A. Tinubu in their school. So they know what they're doing. You can't hold someone culpable for affirming what exists. But the situation changes when you demand for the particulars of the person, which surprisingly they've said that they don't have. They don't have records of how he paid for his tuition, his international passport, and other relevant information that a prospective student must provide to a school before being granted admission. Number four, they will explain the authenticity of the letter he wrote, including who requested for the letter, who prepared the letter, and to whom it was sent. Number five, they will explain CSU's position on the authenticity of the all documents and other facts regarding why the documents were certified, if he was authorized to do it, who requested the documents, and to whom they were sent. Looking at the scope of what Atiku is demanding, you will understand that there is fire on the mountain. No one will be willing to sacrifice his career or possible jail time for anyone for any amount whatsoever. The United States operates a credit economy. If you can't repay your loans, you lose your credit rating. Anyway, before we see what the judge ordered CSU to do, people should appreciate the American justice system. No matter your reservations, they are still miles better than ours. No system is perfect, but when judges make it obvious that they are rewriting the laws instead of interpreting the law the way the lawmakers pass them, which shows their intention when passing the law. But no, judges will prefer to shamelessly and blatantly turn them upside down.
After all the paperwork that we normally do are done, the agents and everybody there, security, everybody will have the papers. INEC will scan or snap the result sheet and transmit or transfer or whatever it is. That whether it is transmit or transfer is that thing that is captured with beavers. The results.
Yes, look at Lawan. He was the Senate president when the Electoral Act 2022 was amended. He explained their intention about the beavers and IREV, everything. Not that it is not clear in the Electoral Act. It is written there in plain English. Even INEC accepted all these. They only said a glitch prevented them from uploading the results. Instead of the judges to hold them responsible for breaching the law, they said that upload of results wasn't necessary. So it means that the legislature and the executive branch, which in this case INEC, the two of them are in agreement that results must be uploaded. But the Judiciary said no, that it is not required. For the record, the amendments to the Electoral Act were sent to the National Assembly by the Buhari administration. They did the amendments, he appended his signature, and it became law. The appeal court judges refused to uphold this law. Back to the district court in Chicago. The moment Chicago State University asked the court to strike out Atiku's case, that they don't want to make an oral deposition, instead that they want to make a written statement. They said all this, and in order to cover their bias, they added that they are not opposed to the release of Tinubu's records. It doesn't make sense that a school will go the extra mile to prevent the release of the academic records of a former student. If they have to put all this effort, that means they have something to hide. When they made this argument at the beginning of hearing, it must have sealed their fate, because the judge can see through the whole abracadabra. Because anyone that is actively preventing evidence, the person knows that that evidence will be injurious to his case. So it's very commendable that the judge saw through all the efforts to prevent the release of Tinubu's records. Compare that to what Nigerian judges did to INEC. They started making excuses for them. The moment the judges saw that INEC were refusing subpoena, even the ones they complied with, they didn't tender all the documents required of them. Where things work, judgment is very predictable, especially when there is abundance of evidence of wrongdoing. Remember, all prosecutors conduct mini trials in order to determine how their case will do in court. The only thing that can make the case fail is maybe how they obtained evidence. That's why they make sure that they obtain proper legal warrants before conducting searches and obtaining evidence. They must convince the judge before the warrant is issued. This is to make sure that there's no abuse of power. Not here that police can arrest someone and refuse to charge the person to court and still refuse to release the person despite a court order ordering his release. They conduct searches of people's phones, wallets, and cars without warrants. This is completely illegal. No court will grant a broad-based, non-specific search warrant to the police. A warrant must be targeted at an individual, not the entire population. Anyway, what is happening between CSU and Tinubu looks like a cat and mouse game. This one will say that they made errors on his certificate. The other one will not admit the errors or even say yes or no to the ownership of the document, but still tell us that the person graduated from the university. Meanwhile, Tinubu never argued at the Presidential Election Petition Tribunal that CSU made errors on his certificate. If he did that, it will mean an acceptance that he forged the certificate. Well, it looks like what happened was that after he successfully took up the real person's identity, the school couldn't issue him a certificate. This was to give themselves room to maneuver out of the situation in case it blows in their faces. The school will be held accountable if it's discovered that they issued a certificate to someone who wasn't admitted to the school in the first place. If it's an honorary certificate, it's a different thing. But once they can't show evidence that the person actually got admitted to the school, it becomes a fraud. Mind you, they are still correct in saying that he graduated from the school because he bears exactly the same name as the person who got admitted. So technically, they can't be held culpable. But a problem arises when admission records show a different person. This is exactly why CSU said they don't have any other information on Tinubu. If you remember, Tinubu claimed that the military invaded his house in the 90s, and as a result, he lost his certificates and other documents. All of a sudden in 2022, he got a photocopy of a supposed lost certificate, which the CSU have now disowned in court. Well, the exact replica of the certificate he submitted to INEC is available online on Pinterest. Now, let's see how the district court in Chicago arrived at the decision in favor of Atiku Abubakar. The court held that Atiku met the 3 grounds for granting his application. Number 1, the person or entity he wants to discover the information from resides in the district of the court. That's Chicago State University. Number 2, the information Atiku is seeking must be used in a proceeding before a foreign tribunal. In this case, the Presidential Election Tribunal in Nigeria or the Supreme Court. Number 3, the application must be submitted by a foreign or international tribunal or an interested person. In this case, Atiku is an interested person, being a candidate in the presidential election and currently one of the petitioners challenging the election in court. You can see why the appeal court gave Atiku's legal team the copy of the judgment on time. They brought this document before the judge in Chicago to convince him that Atiku can no longer tender Tinubu's records in court since they've delivered judgment. This would have breached one ground to release the documents to Atiku, but Atiku countered that he will use it on appeal to the Supreme Court and that the US court shouldn't consider admissibility before ordering the release of the documents. The court agreed with him anyway. It shouldn't be the business of the court in US to consider whether the records they want to order their release will be admissible in a Nigerian court as a precondition before making the order. This singular act by the appeal court in Nigeria lends credence to the rumor that the judgment day was shifted in order to beat Atiku in Chicago. If you remember, after they delivered judgment, Atiku's lawyer pleaded for the petitioners to be given the copies of the judgment same day because their 14-day period to appeal at the Supreme Court already started counting. But the presiding judge refused, saying that it was already late in the day. He promised the next day. Eventually, they were given the copies of the judgment 2 days after. The appeal court judges didn't even try in any way to hide their bias. They were blatant about their partiality. So imagine facing such judges. Even if you bring a video of a public official committing a heinous crime, they will tell you that it wasn't intentional. That's what they said about Shetima's double nomination, that he intentionally did not make himself available to be nominated twice. Even the respondents did not make this kind of vague argument in court. The judges made it on their behalf. Next, on how the US court reached their decision, they agreed with Atiku that he already presented the evidence that Enahore Eba got from Chicago State University to the Presidential Election Petition Tribunal. The fact that they didn't consider the evidence still doesn't stop him from using it at the Supreme Court. Tinubu's counsel was arguing that according to the judgment of the appeal court that Atiku didn't front-load the evidence, that it was a later addition. The judge saw through all the effort to stop the release of Tinubu's admission records at Chicago State University. If Tinubu honestly went through this university as he claims, why is he making it difficult for Atiku to find out by himself? They wanted to convince the judge that the Supreme Court will not admit the evidence from Atiku. How did they know? Are they Supreme Court judges? Did the Supreme Court judges make this information available to them? Anyway, Honorable Judge Gilbert didn't agree with them because obviously there's no way they could have known or deciphered whether the Supreme Court will admit the evidence or not. Now, to what the court ordered CSU to do, part of the conditions for the release of these records to Atiku is to consider whether his interest outweighs Tinubu's privacy. The fact that he has the right to keep his school records confidential is important also. But Honorable Judge Gilbert held that Atiku's interest far outweighs Tinubu's privacy claims because he made his certificate an issue when he submitted it to INEC while filing his particulars for the presidential election. The court agreed with CSU on Atiku's request number 4 that it will be burdensome searching through their database to get the information, especially when the time is too short, only 2 days. So Atiku won't be getting that information, but the court disagreed with CSU and ordered them to make oral deposition under oath. The court said that CSU failed to establish a good cause for the court to require Atiku to proceed with a deposition by written questions, that oral deposition is the most effective method to obtain information from a deponent under the circumstances of the case. Chicago State University had earlier argued that under federal rules of civil procedure that they were entitled to answer Atiku's request with written responses. This is where it gets tough. Like already said, they all understand what it means to lie under oath. So despite the fact that Atiku amended his subpoena by reducing his request, he can still get all the information that he needs through an oral deposition. What he just needs to prove is that Tinubu forged his certificate. It's public knowledge that he wasn't the person that was admitted to CSU, but that wouldn't disqualify him going by the Nigerian Constitution. What will disqualify him is certificate forgery. In summary, Atiku's request was granted by the court. Chicago State University will produce all relevant and non-privileged documents to Atiku within 2 days. Part of what the oral deposition will do is to answer questions about James Orr, who certified all the documents from Chicago State University that Tinubu's counsel tendered at the Presidential Election Petition Tribunal. So you can understand where Atiku is going, why he wants them to make oral deposition about this guy. So if this guy didn't really do the certification, it will mean that Tinubu's counsel presented false evidence and deceived the court. Whether they deceived them or not is irrelevant now, but it will show that their judgment was flawed, which will form part of the grounds for appeal at the Supreme Court. That's if the Supreme Court will consider them in the first place. The Nigerian judiciary should try and learn from the Americans. No matter your reservations about them, you must admire the independence of the three branches of government. Everyone asserts his authority without undue influence, which is exactly the opposite in Nigeria. The actions of the courts lately can be summarized in two ways. One, they will delay or speed up the timely delivery of judgment once it's not going to be favorable to the executive branch, like they did before the inauguration. Even the Nigerian lawyer, Mike Enahoreba, who received the documents from CSU last year, they refused to assign his case to any court for hearing up till today. This is despite the fact that he filed his case in December last year before the election. And going by what the appeal court judges said, that all issues relating to qualification of a candidate are pre-election matters. If that's true, why didn't the court hear this pre-election matter? Number two, they are ready to go the extra mile to defend someone if it means rewriting the laws or in some cases maliciously omitting subsections of the Constitution in order to achieve and justify their actions. In one of the videos we made after the judgment, we highlighted the intentional omission of a subsection by the judges in order to achieve their conclusion. We look forward to the legal fireworks at the Supreme Court.
Could this be a crucial moment in Nigeria's political history? I'm wondering what your assessment of how crucial a victory this is for Atiku Abubakar and the PDP in Chicago.
Well, thank you, Charles. Nice to be in the studio again. Even if I'm not in the main studio, but at least I'm in the studio and I can follow proceeding, accurately. However, based on your question, I don't think, when the story broke yesterday, this afternoon, there was celebration. But the question we should ask is this: what will be the effect if the document is released? What will be the effect? Does it have any consequential effect on the eventual outcome of the decision already reached without prejudice to the final decision as expected from the Supreme Court? Will it have any consequential effect? Certainly not. Certainly not. It's not going to, because I'm not a lawyer, but I've had the privilege of having a legal opinion, a legal expert weighing on the issue. And from all indication, look, the decision to be reached by the Supreme Court is not going to be affected by whatever document that the Illinois High Court is going to, Chicago State University, based on the Illinois High Court, the decision is going to release to the public. It's not going to have any consequential effect. If, in any case, it's going to be two ways. Either it affirms the record already in the public domain, or maybe it could disprove most of the document already put out there by the Tinubu camp. If that be the case, what I see is that it will only put a moral burden on Mr. President, not that it's going to compel him in any way to leave office. So at the end of the day, it may lead to agitation on moral grounds. And it could lead to maybe, in another instance, make the National Assembly to proceed against him on moral grounds. But that is going to affect, because what the Supreme Court is sitting on is what is already before them, the judgment of the Presidential Appeal Tribunal, or the Presidential Appeal Court. They are sitting on that decision. I don't think they're in a position to receive fresh document or any fresh document in relation to what has been decided on. They are sitting, a decision has been reached, so they are sitting on that decision. And of course, we do know that Atiku and Peter Obi have already filed grounds for appeal, which excludes whatever document will be presented maybe before the end of the week, like you said, from Chicago State University. I don't think it will have any consequential effect in regards to the Supreme Court's judgment.
Okay, well, thank you very much indeed for that opening intro. And let me come to you, Dr. Ikoku there, because I would imagine that, contrary to what Dr. Austin Maho is saying there, that this goes beyond a moral issue. It's a constitutional issue. There's an issue of the legality of a submission under oath to INEC if that is found to be false. Atiku Abubakar, of course, has always argued that Mr. Tinubu should not have been allowed to run for president because he had submitted what Mr. Atiku said was a forged document under oath in violation of the Nigerian constitution. What's your take on that?
Well, the starting point is that President Bola Tinubu's case or academic records has been under contention and litigation for a long time. You know, almost the whole of his political life, and this includes his primary school certificate, his secondary school certificate, and then the university degree. In this particular case, what I think that the opposition is doing is to see that they exhaust all available channels to show that there are questions to the integrity of his background or the background that the president has presented to the public. Yes, the first speaker mentioned that it might not affect the Supreme Court judgment or the Supreme Court verdict, but I suspect that part of the thing that's going to happen here, if these records are released and it happens that indeed he attended Chicago State University, okay, that's good for him. It puts paid to all the suspicions and rumors regarding his record from that university. But if it does not, if it turns out that he did not attend that university or something else happened, I think part of the thing is that they want to, as much as possible, bloody his image and his reputation. There are so many things that have been thrown against the president, or they have been thrown against the president, and this has happened throughout his political life. And yes, he is the president. He might win at the Supreme Court legally, but morally he carries around that burden. Morally, there is the lack of belief or believability in this person and in who he says he is compared to who he is presenting to the public. So I think these are the things that are going on at this particular time. And it's also a big news for the opposition party. Why? Because the camp of the president had tried to make sure or to fight against the release of this record. So the fact that the court in Illinois decided that it is important that this record be released, I think is a breakthrough for the opposition. Whether or not it impacts the Supreme Court is another thing, but it is a breakthrough for them nevertheless.
Well, let me come to you, Baba Yusuf, because we know that recently Chicago State University appeared to confirm that Mr. Tinubu attended the school and graduated with a bachelor's degree in 1979. I mean, in that regard, do you wonder why Mr. Abubakar and the PDP have persisted in their quest to gain access to Mr. Tinubu's records?
Thank you, Charles. I think why the opposition candidates are pushing forward to this level is that a court of competent jurisdiction within the United States of America, having taken this position, will be the last line of what I call validation or otherwise of the credentials of Mr. President vis-a-vis his degree that he earned in the Chicago State University. This, to my mind, will bring to rest the issue and controversy around the truth or otherwise of President Tinubu attending Chicago State University and graduating. So from the perspective of unraveling or validating what is there as a truth is key to Nigerians, is key to the history, to the political history of Nigeria. And if affirmed or confirmed to be true, will further validate and give more credibility than it is to the presidency of President Bola Ahmed Tinubu. Further to that, to add my voice to its impact on the Supreme Court consideration, as the first and second speaker mentioned, it is elementary in law that matters that go to the Supreme Court will not be subjected to fresh evidences presented before the apex court. The court will consider all issues before it in line with the judgment passed by the Court of Appeal. That being said, if for any reason, contrary to the truth comes out as the fact with regards to the credentials of Mr. President, it will surely stir the hornet's nest within the polity. First of all, the moral issue on the legitimacy of Mr. President sitting with regards to the forgery case, which becomes a perjury issue, becomes a criminal issue on one part, beyond the qualification issue. Mr. President already is Mr. President. He's enjoying immunity as we speak as president. What will remain to be seen is how that will pan out with regards to his being an incumbent president. If for any reason it is, the deposition by the school, which I suspect will not be different from what they have come out to say. I don't foresee an American institution like the Chicago State University to come out with a contrary view from what they have brought out to the public, on their own independently, especially given the fact that this matter has been a thorny issue. In fact, the Nigerians and other interested parties had to force the Chicago University to come out to say, hey, these are the facts with regards to, the credentials of President Bola Ahmed Tinubu in our records. However, a court deposition will put to rest this issue going forward.
Okay, well, thank you very much indeed for that. That makes a lot of sense, what you just said. Let me come to you, Dr. Austin Maho, still marooned as you are in our off-site studio. Obviously, listening to Baba Yusuf there and before him, Dr. Ikoku, the reason we're following this so intensively is because if by some freak of circumstance these records confirm what Atiku and the PDP have been suggesting, it could have the sort of impact on Nigeria's politics that far outstrips anything we've ever seen before, couldn't it?
Yeah, certainly. Like the two other panelists have succinctly highlighted, it will have significant impact. And like Dr. Ikoku said, I took note of that. Look, and like I highlighted earlier, it will only place a strong moral burden on the president who would have been guilty of perjury, lying to the public under oath, and presenting documents which is not a true reflection of who he is. That is, if at the end of the day, the ruling or the document released by Chicago State University is contrary to what they have already put in the public domain out there. And like I said earlier, it can only give grounds for the National Assembly to proceed, maybe to proceed by taking an action of impeachment against him, to say, look, he's not a fit and proper person to be the president of the Federal Republic of Nigeria. Or there could be agitation in the public space, in the civil space, for him to voluntarily resign from office on grounds that, look, you have been caught to have lied because you've been caught in a lie, and consequently you are not a fit and proper person. You have a moral question on your integrity, so you are not a fit and proper person to preside over the affairs of 200 million Nigerians. That's as far as it goes. But like other panelists have highlighted, in my heart of heart, I don't think the document we are expecting is from Chicago State University is not going to be significantly different from what is already in the public domain. So the agitation, the hope, the tension over what is to come, I don't think there's any need for it. Rather, I would like us to pay attention. There's a ruling based on America's FOI Act that a Nigerian investigating journalist was able to use American FOI Act to compel the FBI to release about a 250,000 page document on Mr. Ahmed Tinubu's activities in the United States, which is supposed to, the FBI have secured, a court has mandated the FBI to release those documents starting from October. And I think possibly that may be more damaging to his reputation, his person, than what we are expecting to see from Chicago State University, by the end of this week. Okay. I look forward to that rather than the expectation from Chicago State University.
Okay, well, thank you very much indeed for that, and thank you to all of you. I mean, at the very least, as you've all said, this will rest the case and the lingering questions over the legitimacy of Mr. Tinubu's educational qualifications. You've all talked about the Supreme Court, so this leads logically and helps us segue into the appeals process. Two losing presidential candidates from Nigeria's main opposition parties have gone to the Supreme Court to challenge the dismissal of their cases against the victory of Bola Ahmed Tinubu as president in February's election. You may recall that an election petitions tribunal ruled in a unanimous decision earlier this month that both the Labour parties, Peter Obi and Atiku Abubakar of the People's Democratic Party, failed to prove that the election was flawed. The tribunal declared that the politicians could not establish the allegations of overvoting and voter suppression. The judges also said there was not enough evidence to support the cases. Well, Mr. Abubakar is asking the Supreme Court to nullify the judgment, saying it occasioned grave error and a miscarriage of justice by upholding Mr. Tinubu's victory. Through his lawyer, Mr. Atiku also faulted the court's use of what he called disparaging words, which he said evinced bias. In a similar move, Mr. Obi noted that the election court overlooked the facts in his case and failed to consider the weight of evidence he presented, thereby arriving at the wrong conclusion. No date has been fixed for the hearing of the cases, and our distinguished panel of current affairs analysts are still with me. Dr. Constance Ikoku is a journalist, political affairs commentator and Arise News analyst. Baba Yusuf is a policy strategist, political commentator, and group CEO of the Global Investment and Trade Company. And Dr. Austin Maho is a lecturer and researcher with Nigeria's National Open University and is also the publisher of Daybreak newspaper here in Abuja, and he is in our off-site studio. Let me kind of reverse the way that we've moved around this time and start with you, Baba Yusuf. Atiku Abubakar of the PDP and Peter Obi of the Labour Party have both filed their appeals at the Supreme Court. I'm wondering what you make of their case at that Supreme Court so far.
I don't envisage anything different from what the PEPC had ruled. Like we said earlier, or like I said earlier, much so the same thing said by the speakers. There's pretty much no opening for fresh evidences to be presented or fresh witnesses to be presented. And therefore, the Supreme Court is going to review the judgment vis-a-vis what was already submitted. In the case of inadmissible evidences, in the case of discredited witnesses, those are the things that they will look at. And then the technicalities around the judgment. Of course, also with regards to precedences. So based on that, and I have studied that judgment personally, my pocket knowledge of the law and strategy, I don't see any variance. Of course, without prejudice to the apex court, those are the ones that will decide. But I don't see pretty much something playing out different from the outcome so far.
Right, but of course, Dr. Ikoku, the grounds of appeal are quite numerous. I mean, you've got Atiku lists 35, while Peter Obi lists 51, and some like Atedo Peterside, who was on this program last night have said their support for the process. They support the process to go all the way to the Supreme Court, and not necessarily because Atiku or Obi, you know, to get whatever it is they're looking for, but to ensure that damage is not done irreparably to the whole system, including things like the Electoral Act, which was supposed to create the environment for transparent elections. With some people seeing what has happened as a threat to those gains, do you think the Supreme Court will be able to tell us which bit of the Electoral Act is still valid and which are not, as Mr. Peterside suggested?
Well, I don't know if the Supreme Court will do that, but the point to note here is that after an election which was generally regarded as below par, and some even use the term shambolic, the ruling party asked the opposition to go to court to seek redress. So they have gone to court, and this is the final leg of that court case. And it is important that they exercise their rights, and this is what they are doing. In essence, at the end of the day, they can beat their chest and say that we did our best. We exhausted all channels that are available to us within the confines of the law. What this Supreme Court case or judgment would do is that, like I said, it gives them that opportunity to exercise their right. And then secondly, for President Bola Tinubu, it is important because if he wins, then it means that it gives him the legal authority, or it stamps the authority for him to carry on in office and not thinking that he will be yanked off the next minute. And for the general masses, it's also going to give them a bit of closure. And a couple of options they will have at that point will be to either quit or to support the president or to remain in the opposition and even become a stronger opposition. So this is a test on our democracy. We haven't had a case as much as this. 3 strong candidates running for presidency. This is the first in the history of Nigeria. And I think this case is going to be a turning point in the history of our country, when indeed it comes true.
Well, let me come to you, Dr. Austin Maho. I mean, you're a researcher, you're an academic, a lecturer, and you're also a journalist. You publish a newspaper. I mean, let's take one ground of appeal and get your assessment of its merit. Atiku, for instance, in his appeal, argues that the tribunal erred in law when it failed to nullify the presidential election on the basis of non-compliance with the Electoral Act, when, by evidence before the court, INEC conducted the election based on very grave and gross misrepresentation, contrary to the principles of the Electoral Act and based on the well-known legal doctrine of legitimate expectation, which demands that a public authority shall respect and apply its stated position in exercising its powers on members of the public. In other words, according to this legal doctrine, INEC, which is a public authority, can say one thing and do another. In other words, it's not allowed to do that. Briefly, what are your thoughts?
No, I believe it's a very strong ground of appeal, because the fundamental of the why many of us agitated for a review of the Electoral Act until it was signed in 2022 by former President Buhari, which was the act that was used to conduct the 2023 election, was electronic result. Electronic transmission of results. So Atiku and his lawyers, in their wisdom, are looking at the issue of substantial compliance. Did INEC comply with its own rule based on the Electoral Act or not? And many people out there will agree that, look, we expected that based on INEC own rule and what they put out to the voting public, was that INEC will conduct the result and transmit the result electronically to the IREF. Because it has been noticed over time that one of the weakest links in our electoral process is transmission of results. Because over time, you find out that between the polling unit and collation center, a lot of things happens. A lot of manipulation takes place. So the belief was that with electronic transmission of results from the polling unit to the IREF portal, it will take care of that gap which politicians have been manipulating over the years, you know, to influence results. But unfortunately, why the Electoral Act gave INEC the powers to be able to transmit results electronically, it equally gave them from what the ruling of the Presidential Appeal Court, it equally gave them the elbow room to decide whether to use it or not to use it.
Right.
But
I
at the end of...
I guess the point really is the fact that they assured the public that they were going to use it, and then they went and did something else.